represent the appellants in this case, the Hilton parties. I'm reserving 5 minutes for rebuttal. This appeal involves a challenge to 2 sets of restrictive covenants for a beachfront subdivision in South Walton County. The trial court should have held that the claim was barred by the statute of limitations. This court addressed the same issue in the recent Silver Shells case and held that a challenge to the validity of a restrictive covenant is barred after 5 years, commencing on the date the covenants are recorded in the public records. Our position in this appeal is that the outcome in this case is governed and controlled by the Silver Shells decision. 2 other cases in Florida reached the same result. The Harris case out of the 4th District had been decided before the final judgment in this case was entered. Our position is that should have been controlling below, but the trial court did not follow that case. We've also cited the Kelly case, which is a case out of the Northern District of Florida, a federal case, also holding that the statute of limitations to challenge a validity of a restrictive covenant is governed by a 5-year statute of limitations. Not disputed in this case. If that statute of limitations had been applied, this claim would have been barred.
Well, your opponent argues that the statute of limitations issue isn't even properly in the case. What's your response to that?
Pearson's argued that it was waived. It clearly wasn't waived by the Hiltons. The Hiltons raised the statute of limitations in their answer when they intervened. We certainly struggled with the association to get the association to raise the defense. The association in this case was aligned with the Pearsons. Although named as a defendant, the association's position was that these covenants were invalid, and it sought to also reinstate the original covenants. But the association did raise the statute of limitations, filed a motion seeking leave.
They did not raise it in their original answer.
They did not raise it in the original answer. Doesn't matter.
And they never asked to formally amend their answer, did they?
They did not ask to amend their answer. They did ask the trial court to consider the statute of limitations. They filed a motion asking the trial court to allow them, the association, to raise the statute of limitations. Trial court granted that motion, allowed the association to raise the statute of limitations. The statute of limitations was argued at trial. We presented evidence at trial showing that the Pearsons, Mr. Pearson, had made a presentation to the HOA board in 2007, 6 years before this lawsuit was filed, making the same arguments that they 6 years later made in this lawsuit. The trial court allowed that because the trial court recognized the statute of limitations was in the case. Now, ultimately, the trial court didn't apply the statute of limitations, but it was raised. It was raised again after final judgment was entered. The trial court initially entered a final judgment that adopted the Pearsons' proposed finding that the statute of limitation was not raised and abandoned. We moved for rehearing challenging that finding, pointed out to the trial court that the trial court had earlier expressly allowed the association to raise the statute of limitations. The trial court granted rehearing in part, revised its final order to remove, said, I'll take out the finding that statute of limitations was not raised and was abandoned. So the trial court directly addressed this waiver argument, ruled on rehearing that the statute of limitations had not been waived, and that is the final judgment that is before this court.
Is that an issue that if they wanted to challenge the trial court's allowing that issue to be considered despite the fact that it wasn't raised in the original answer, was that something they had to cross appeal, or is that something they can bring up?
Would have to be cross appealed. It's a direct finding by the trial court that the statute of limitations was raised, was properly raised, was not abandoned. If the Pearsons wanted to challenge whether that was a correct ruling to allow the association to raise the statute of limitations in this case, after not originally raising it in its answer, it didn't raise any defenses in its answer and was prepared to admit all of the facts on which judgment would have been entered until the Hiltons intervened. The Pearsons would have had to cross appeal that determination and would have had to challenge whether the trial court properly allowed the statute of limitations to be argued in this case. But it was clearly argued. Now, the trial court ultimately did not apply the statute of limitations, but there's no question that it was raised in the case, was raised by the original defendant after somewhat of a struggle, but it was raised by the original defendant, and the trial court then later specifically addressed the issue on rehearing as to whether it had been waived and ruled it had not been waived.
If we agree with you that the statute of limitations is properly in the case and that Harris and the Silver Shells case controls, is the remedy a reversal and remand for directions to enter judgment against them, or are there are there issues that need to be litigated about waiver, or excuse me, about latches or those types of
No
things?
further issues need to be decided, no facts need to be determined in order to apply the statute of limitations in this case. There's the only facts that you need to know to apply the statute of limitations is when were the restrictive covenants filed in the public records. In this case, the most recent covenants.
I guess maybe I wasn't very clear in my question. Was there any avoidance of that statute of limitations defense raised, such as latches or equitable
The Hiltons
estoppel or
alleged
anything
a
like
latches defense, but there was no reply to that. They filed a reply, but they did not raise a defense to the statute of limitations defense.
Okay, so there wasn't anything like you lulled us into believing that the statute.
They've argued that, they've hinted at that argument in their brief based on this attorney opinion letter that was released and that was issued in 2007. There was no tolling argument that was made. There was no tolling argument that was alleged in a reply. There was no tolling argument argued to the trial court, and the discovery rule, that was addressed in the Kelly case, the discovery rule under which the statute of limitations can be told or it doesn't commence until certain facts are discovered doesn't apply in Section 9511(2)B. Kelly case cites some Florida law on that. The statute of limitations commences when the restrictive covenants are recorded in the public records. Here, the most recent recording of the challenged restrictions was in 2005. This case was filed in 2013. The other challenged covenants were recorded in the public records in 2001, almost a dozen years before this lawsuit was filed. So we don't believe there's any question that the statute of limitations should have been applied. Controlling authority out of this court, out of the 4th District, directly addresses this issue. And in this case,
if I could ask, they seem to suggest through this analogy to a fraudulent deed or something that somehow what was put into the public records in 01 and maybe 05 was void or voidable, and therefore they shouldn't have. Their theory, I think, is that they should have known about it. So I guess the question is, I understand from the record that Mr. Pearson showed up at some meetings, actually made some presentations and so forth. There seem to be two things going on here. Is the statute of limitations triggered by the filing of the revised restrictive covenants, no matter how voidable they might be, or is it really a fact-based determination on what Mr. Pearson may have known?
well, the law on that issue is that the statute of limitation commences running when the challenged covenants are recorded in the public records. The Harris case cites some cases in Florida that Florida is a constructive notice case. Once an owner of property is presumed to be on constructive notice of matters in its chain of title. Here, there's no question that Mr. Pearson had actual notice that these covenants had been adopted. He made a lengthy presentation, over 2-hour presentation, at an October 2007 HOA meeting, challenging these covenants on the very same basis that they've been challenged in this lawsuit. So,
Did he actually vote on them? Because it was a little unclear. He was asked, did you vote in favor of them? He said, no, I did not vote in favor of them, but he didn't say he actually voted.
they allege in the complaint that they did not vote in favor of them. I do not know that the record shows whether he voted one way or the other. The allegation is, and his testimony was, he did not vote in favor.
Where's your client's lot? What's your lot number?
I can't tell you the lot
On the
number. Our
beach.
clients, there are several lots involved. One of the trusts owns 2 lots on the beach, kind of in the center of the subdivision. Another lot is further north of that. I don't have the lot numbers.
The reason I ask, I'm just trying to get a sense of what's going on here, because it seems like it's this battle for control over this plot of property, which largely is undeveloped, it looks like.
No, I don't believe it's largely undeveloped, and very candidly, we were never able to figure out exactly what the nature of the dispute is, other than the plaintiff in this case, the Pearsons, argued that these covenants were invalid. The basis for that claim is based in contract. It's based on the voting provisions, the amendment provisions of the original covenants. Now, one of the claims here is that the controlling cases, Harris, Silver, Shells, the Kelly case, don't apply here because the Pearsons have challenged, they say, a conveyance of real property. That is not the claim, never has been the claim. If you read the complaint in this case, the only claim in this case was that the amended covenants are invalid because they were not adopted by a unanimous vote of the property owners, alleging that the original covenants required a unanimous approval of these amendments. Now, we think that's a misinterpretation, and I'm running out of time here, but we believe that is the wrong interpretation of those voting provisions, and that the trial court's interpretation essentially preempts, and as the Pearsons allege in the complaint, trumps this two-thirds, just reads the two-thirds amendment procedure entirely out of the original document. But the claim was based on an alleged violation of the original covenants. Covenants are contracts. They're not conveyances of real property. They are not interest in real property. The rationale of Harris, Silver, Shells is a claim based on a contract, including a restrictive covenant, is governed by a 5-year statute of limitations. Here, that statute of limitations clearly wasn't met. I'm going to reserve the rest of my time for rebuttal.
Thank you. Mr. Bentley?
May it please the court, I'm Fred Bentley Jr. Thank you so much for allowing me to appear in your court on a pro hoc basis, and I do appreciate very, very much the courtesy. I'm here representing the Pearsons, and I want to start out, and I think, Judge Weatherall, you started with an excellent question in terms of the issue of whether or not there was a waiver of this statute of limitations. Now, of course, we maintain there's a different statute of limitations, and it never applies because it dealt with the issue of the granting of property rights, and that is a major distinguishment.
What, in your view, is the statute of limitations?
Be a 20-year statute of limitations, or because it's a void document, it would never grant anything, and the statute of limitations does not proceed to run. So it would either be under the 92-231.231, which provides for the 20-year, or it would be simply void ab initio and therefore grant no rights.
I don't recall the trial judge ruling on that issue. Could you point me to something?
Well, the trial judge found it akin to a forged deed under the Wright versus Blocker, and the Wright versus Blocker case, that's what the case deals with in terms of that statute of limitations issue. So let me go in.
So your answer is he didn't?
No, he actually ruled under Wright versus Blocker that that's a void instrument, and therefore it affords no notice. It affords no notice for purposes of a statute of limitations argument. The cases that are cited by counsel, and I want to talk a little bit because unlike those other cases, they dealt with assessments and covenants, and we're dealing with the grant of property interest. And that is an important distinction because if you go into that, it's really akin to a deed titled an amendment and restated covenant. And what it did, there were no less than 26 enumerated property interests that the court found that were transferred. Let me just go through a few of those because I think it will help you understand why this is, that analogy is appropriate.
Well, if you, we have it all in the record, in the briefs and so forth, and
Yes,
you can spend your time the way you want. But
yes, sir.
It seemed to me that there was just a couple that your client was concerned about, and when asked about them, he basically said that he was fearful that he couldn't go over the beach walk over the dunes that's right in front of his property, and that the restrictions would force him to go a quarter mile down the road and then go across it. But other than that, he really didn't have anything other than a fear that something might somehow transpire at some point.
Well, they have not imposed, when you're dealing with the imposition of those things, the answer is yet. And when you go to those things, it's like the number of family members are limited to 5 people. It says they can take away the veto right, deleting the express provision of 100% concurrence in any item. So there was, in effect, a veto right that was...
Well, why didn't your client file suit? at the time he was complaining to the board about it.
Well, there was an opinion letter that was hidden. And the court even said this was hidden. And there's testimony, and I'm sure you had the opportunity to read the testimony, that the Hiltons who are here are the party that actually led the association and put that in place.
But it sounds, well, I'm sorry to interrupt, but
Yes, sir.
your client knew there was a dispute. He may not have known about this legal counsel opinion from Mr. Theriak's firm, but he knew there was a problem, and he never acted upon it.
They were told, and the evidence shows that they were told that it was valid by Ms. Hilton, who was the president of the association, who had procured an opinion that the association paid $10,000 for but was withheld from the membership.
And that opinion letter, in short, said the amendments are invalid?
Yes, about 95% of the opinion said exactly what the circuit court undertook and said that they did not have the authority to do indirectly what they.
Well, that's not exactly what the letter said. The letter is a classic lawyer's letter, which said, here's the law, here's the facts, here's my assessment, I feel like it's valid. However, there is a risk that a trial court could overturn it. And here's the
Well,
that's what it
but
said.
then there are also letters that were introduced where she even wrote a letter back and signed it, where she agreed that that the opinion letter showed that it was a very dangerous letter, that it was, and she actually wrote two versions of the letter. And if you go to the record, and I apologize, I didn't realize I needed to be able to refer to that to you, where she acknowledged that this was a problem, that this opinion talked about the invalidity. That's the reason it was hidden until 2011.
Well, I guess that goes to the question I asked Mr. Hall is, I mean, typically if you raise a statute of limitations defense, let's assume it's properly in the case. I know you argue that it's not, but if it's properly in the case, then you either say that it's not barred by the statute of limitations, or for some reason they should not be allowed to apply the statute of limitations against me. Either they're stopped from doing so because they told me something, or they lulled me into inaction. I'm not seeing any allegations in a reply to the affirmative defenses that would raise that issue. I think you're kind of arguing that, but I'm not sure that's properly in the case.
Well, of course, the court will recall they were mere interveners. They were not deemed indispensable. In the original answer by the association, it was not raised as an affirmative defense, which is required. Thereafter, it was raised by motion. As this court knows, in Aiken versus City of Miami, 65 Southern 2nd 54 of Florida Supreme Court in 1953, it says that it has to be affirmatively pled rather than purported to raise it by motion, which is improper under Florida law. So we objected to that being raised at every juncture. And so even the motion was, well, we think this is an interesting point if the court wants to try to address it. So, again, we objected at each juncture, and under the Tipsy Coachman rule, which I have learned a little bit about since coming here, McNeil versus O'Neill, 238 Southern 2nd 614 of Florida 1970 case says that if we prevail, we're not required to raise it.
Just to put a finer point on it, your objection was it's procedurally improper to be in the case. Your objection wasn't we have a legal reason, factual reason that you should not apply it to us.
Well,
That's
no,
the difference, isn't it?
well, we do believe that there's a factual reason why, because it's akin to a deed. If you look at these 26 interests, even if you go directly to the cases, and if you go to the Kelly case, which has been cited.
Okay. Before you do that, let me try to bring this one to a close.
Yes, sir.
As I see the case, if we were to agree with Mr. Hall that the statute of limitations is properly in the case, the result of our disposition would be a reversal and a remand for entry of judgment against your client. Do you see a different disposition? And if so,
absolutely. We would, of course, certainly agree or disagree that it has been properly raised.
I understand that.
But outside of that, at a bare minimum, it should be sent back for us to address that issue, since the court found that it was not applicable.
Address what issue?
The court addressed that there was no statute of limitations issue because he said that it was not applicable. There was actually a motion for summary judgment on it.
If we say as a matter of law to the trial court, you're wrong, it is applicable, what would we send the case back on?
It could be remanded for purposes of consideration of the hidden opinion, for purposes of how our client told the statute of limitations would be told, because there was testimony that my client was told that it was legal. The association was told that by Ms. Hilton, and so there's an estoppel argument that would be appropriate.
Was that pled? That's
Yes, sir.
Where was that pled?
I believe in the amended answer that we filed to the counterclaim.
Your client's a developer, isn't he?
That's correct,
He
sir.
had over 100 properties, he's written covenants, he's got vast experience in this area.
That's correct, sir.
I'm still having trouble about why he didn't pursue it at the time. I mean,
Well-
I understand that there's this letter that hanging out there, I'm just,
Well, I think
is that something we have to have factual
you-
development on?
Yes, sir. If you look at it, there was 100%. When someone takes away your property right, which as opposed to Harris and Kelly, you can't just you can't land grab somebody's property. And there was more than just the one item, Your Honor, that you pointed to, because they removed the access to the beach, which you did talk about. It allows them to build a wall around my client's
Yeah,
property.
there's a lot of easements where they look very onerous.
Yes.
Just
Okay,
like
and
that.
those are property interests as found by the court that are taken from my client without a vote, not only by my client, but by several other members of the association.
Well, the other thing that struck me, I mean, if we get to the merits, I think you have a strong argument on certain components of it, but there was also a severability clause in the amendment. So why wouldn't that,
If it's found to be a void,
strike out certain things?
if it's found to be a void document under Wright versus Blocker, the entire instrument is void, and it gains no rights and no status as it relates to that. So that would be the response to your question, because you can't simply go add a severability clause after the fact.
So the
where it's
original
not properly, because it affects my client's
The original
right.
declaration didn't have a severability clause?
No, sir, it did not.
Gotcha.
The 1994 had no such thing. As a matter of fact, recall that it allowed, consistent with the law, 100% requirement before you could take away any property rights or any grant of property interest. There were 4 separate things on page 16 of the 1994 covenants.
It sounds like the exact same argument that the plaintiff made in Harris. They argued that the amendments to the restrictive covenants were void. They were void ab initio. That argument failed. Why is this different?
As recognized in the Kelly case, which the 2 cases arose out of similar circumstance, it says, as in Harris, it says, for the purpose of these claims, she is challenging the validity of the assessments. As in Harris, the assessments and the claim arise out of contract, not any grant of easement. We're dealing with easements here. So there's a clear distinction as it relates to the applicability of the case. The other point that I would point out to you is recall that under Florida statutes annotate 817.535, which we did not cite in the briefs, and I apologize to the court for that, that is a statutory provision that keeps people from filing the interests that affect people's property where they don't have a right to it. It, matter of fact, provides criminal penalties, and it also provides an additional right of action under that code section. So this is against not only public policy, but if you think about it, if I just simply go in and say, well, I'm just going to put covenants on your property, and then turn around and grant all these easements as it relates to your
I
property.
guess the difference would be there were already covenants and restrictions on this property. All this case was about were the additional covenants and restrictions, and whether those additional covenants and restrictions changed property rights or whether they didn't.
No, but it's also, they actually take property rights. They actually got a power of attorney. They actually got a right to go on my client's property and everybody's property there to go on there and tear down structures. I mean, those are very different rights. I mean, that's like somebody coming and saying, well, I'm just going to take this part of your house. And that's somehow valid when you don't sign it. That's never been the law anywhere. I mean, that's against public policy. You have the right to your property unless somebody gets your signature. And so that is the reason, that's the major distinction between all these other cases that they've cited.
But if I understood correctly, the original amendments allowed, or excuse me, the original declaration allowed amendments with a 2/3 vote unless they changed property interests, at which point they had to have 100%. So you do agree that certain amendments could be adopted with a 2/3 vote?
Yes, sir, if they had done it, but again, they fall as a group because there was no severability clause, just as you pointed out, under the original 1994 amendments.
Where are the Hilton's properties?
I'm sorry?
The Hiltons, where are their properties, or property?
Their waterfront, or one of the properties is waterfront and another is back off one of the streets. And then my client's property, Mr. Pearson's, is on the eastern boundary.
Because it looks like it's fairly undeveloped. I mean, it looks like maybe only 40.
Well, there have been a lot of homes that are going up and being developed, I guess as we speak. It's very active. I think that whole market has recovered. So, well, we appreciate the opportunity. Thank you for the opportunity to be here.
This case was never a challenge to a conveyance of a property right. And we talked about that in my initial argument. This case was always based on an allegation that the original covenants required a unanimous vote under the Pearson's interpretation, the interpretation that the trial court adopted, to change virtually anything. And the trial court reached that conclusion by interpreting property rights in that restriction on amendment in the broadest possible way, so that any right that is associated with the ownership of property can't be changed unless there is unanimous approval. That included things under the trial court's judgment like what kind of signs can be put in a person's yard, what kind of vehicles can be parked in their driveway.
Well, let me ask you this. There's certain rights. I mean, if I read this covenant initially to say, we will protect your property rights. Why? Because they're important and because we'll have unanimity of vote. And then the property owner relies upon that. You can't change the restrictive covenants to now allow easements over my property, to allow walls to go up, to allow beach access across my property and so forth. Well, why shouldn't we say that that sliver of it is a property right that requires unanimity and hold it void?
The one sliver of it that we agree in our brief constitutes a change in a property right that would require unanimous approval and the joinder of mortgagees. And that joinder of mortgagees has to be given some meaning. It's different from the 2/3 provision. 2/3 amendment doesn't require joinder of mortgagees. The unanimous requirement does. The restriction does. What does that mean? We think it means that the kind of property rights being addressed in that restriction are those that would change a legal title, change an owner's legal title to property in such a way that might impact a mortgage lien. You require that's consistent with the attorney who drafted, who testified, who said that's what we intended. The perimeter wall easement, we acknowledge. That purports to impose an easement over not Mr. Pearson's property. His property is separated from that eastern boundary by another lot. So he's not affected by that at all. But that is a property right. We would acknowledge, and we did, acknowledge that that is the kind of change in legal title.
Well, why wouldn't all of the easements, whether it be for mowing, whatever it is, I mean, the property right includes the right to exclude others.
It does. And
Before
those
they
are
had
all,
the right to exclude the association to come in and mow their property and destroy structures, and now they don't have that right.
those are called easements in the document. We acknowledge that, but they certainly operate more like a license. They operate more like a limited grant of a right to the association to come on the property temporarily for a limited purpose to accomplish a very specific thing. If somebody's letting trash pile up in their yard, if somebody hasn't mowed their yard in 6 months, to do an inspection. I didn't see anything that allows the association to tear someone's house down. That sounds a bit extreme. But to perform an inspection to see if the owner is constructing the building in accordance with the plans that have been approved. The plans were required to be approved even under the original covenant. So those kind of things, are they labeled easements? They are. Would they affect legal title in such a way that a mortgagee would be interested in them? No.
So could I ask you, so the person who has the border lot can come in and file suit regardless of any statute of limitations, is what I'm hearing you saying?
If there were a genuine dispute over that, there was no evidence that the association has ever attempted to enforce a perimeter wall easement or claim any easements in any one property, certainly not in Mr. Pearson's property. Depending on the circumstances under which that owner took title, when and how, that would be a different case. We certainly don't have that here. We don't have any such dispute here. And very briefly, this is not like a void deed. The association has authority to amend these covenants. The question is whether that was properly exercised. Contract claim, 5-year statute of limitations.
All right, thank you, counsel.
Thank you.
We will be in recess and invite you to join us in the rotunda.